David Tillis here at 92.7. We argue for near over far, small over big, and simple than complex. And in 5-point type in Helvetica font, the neutral Swiss font, where it doesn't make war on anybody, it doesn't try to attack anybody, it doesn't try to entangle anyone or anybody or any person or anything in regulation and red tape. We have personal is better than corporate. And in one line below, also Helvetica font, the neutral font, physical is better than abstract. That's the kind of the Christian analysis of the marketplace, I would suggest. Very holy, righteous, and true, and encouraged by Holy Writ. A couple of days ago now, there was a hearing in Dunlap, Tennessee, where Carol Gaddy was making a case. She has been stiffed and harassed and hammered by state actors and municipal actors for nearly 4 years. And now they have they are, perhaps you could say, ruining the day that they tangled with this ferocious, independent-minded woman who has a real estate background and lives on Main Street, not about a carbine shot from City Hall, in a bend in what's called Coops Creek, C-O-O-P-S Creek, a house built by a former judge just after the war to prevent Southern independence. It was a long court battle over whether the city had a right to or the authority, the power to inspect that house without a warrant. And she stood her ground, I would say, very, very well, in an admirable fashion. And now, since she has enmixed herself with the Philistines and now has cause against them, she is dragging their tail end before the Secretary of State's office and demanding proof that the city back in 1972 annexed as much as 20% of the town. That includes allegedly her house, her and her husband Thomas's house. Carol, what was the hearing about? It was about a 90-minute affair, and you were there as in your making your own case. What was the argument you were making, and whom were you quizzing from the witness stand?
Well, David, this was the hearing before a administrative law judge who is with the Department of State, Secretary of State's under his authority. And we are asking, based on a new law that our General Assembly passed in, the governor signed it in May 2015, that a private property owner may challenge a municipal government for the legality of their annexation. Meaning, if the city fails to prove up of a legal annexation upon that property, the city must pay that property owner back all of their taxes that they have paid, plus interest. It's a very important law, and I've got a copy I'm leaving here with David so he can publish it, and everybody can look on his site and get the exact wording on that. So we challenged jurisdiction, annexation from 1972. It would have been 44 years ago. Now, we had only one witness, and we called Ivan Condra to be that witness because his trade was as a surveyor in that valley. He's lived there. He's in his 80s. He's lived there all his life. And then he spent nearly 30 years in the tax assessor's office. So we regard him as an expert witness as far as knowing the growth through annexation and surveys for the city of Dunlap. The city has yet, we challenged jurisdiction in the Chancery Court before this Department of State case became active in March of 2016. And we have begged the city through the court to furnish some documentation of proof that they actually performed a legal annexation, and they will not offer the proof. To this day, they have not, and they haven't even offered the proof at this hearing.
Well, that's what really struck me, Carol Gaddy, the history of the case that Judge Steve Darnell made. He said there was an order made against you on the preponderance of evidence. That was Rachel Waterhouse's ruling in October. Then the order was set aside by another Administrative Judge Richard Collier, and then the case was assigned to Darnell. Why? To have you give your evidence, which was denied earlier. So I don't understand this Department of State's case and your claims in its venue to have relief.
Well, David,
how come Condra wasn't allowed in earlier? That, I guess, is my question.
Well, he was there. He was there at the October hearing, and he was ready to testify. But when City Attorney Steve Greer would go outside, all the witnesses were outside the courtroom. And of course, Attorney Greer presented first. And when it was our turn to present our witness was no longer there. When we phoned him, we asked for a 10-minute recess. Judge Waterhouse granted it. We phoned him. He was all the way back home and said that Stephen Greer told him that he could leave if he was not there by subpoena, that he didn't have to stay. So because that witness had been, what I use the word, tampered with by the opposing party, the city attorney, on that grounds, it was the procedural grounds, we were able to raise a motion for this new hearing. That's the story on that, David.
Okay, so now Mr. Condra, Ivan Condra, 84, property assessor for 7 terms, who came with no papers. He said, "No, just what's in my head," is what he said, and on the witness stand, he just spoke sort of from memory and sort of theoretically. So what was it? The listener wants to know what your argument is in this hearing, Carol Gaddy of Dunlap. What was the argument you were making? And then tell a little bit about what Mr. Condra said.
This is a genuine issue of material fact that in 2015 on the internet, the charter for the city of Dunlap's legal description under Section 3 boundaries, their southeast corner was on a stake in the center of Coops Creek. Now,
the creek that runs around your property.
That was their southeast corner now. So they said all their expansion went westward and northward of Coops Creek. Well, my property begins in the center of Coops Creek and it's southward of that city boundary. So we said, okay, 44 years ago, they claim an annexation, but why, if they've had 44 years to update their charter and put their new legal description or boundary description, either one, to the public, it makes me wonder, how does...
and that charter was revised or edited only in 2016.
Well, it has been updated and amended. There's probably the Secretary of State's legal archives, Vincent McGrath, researched all the resources, and I have the letter. There were people that thought that when I received this letter from the Department of State stating that they could find no concerning municipal boundaries annexation, the city of Dunlap and Sequatchie County, our staff was not able to find or identify additional laws in our indexes that matches your inquiry. And they even listed, okay, that is the state's legal search of acts, and they found nothing. So I say they do not have jurisdiction over our property. So why hasn't this case been dismissed? It should have been dismissed in Chancery Court. You're talking about the Chancery case now, not the case before the Secretary of State. Right. Okay. Oh, I'm sorry, David. I should have clarified. Right. Well, I thought that case was dismissed. I thought you were allowed out of jail, Carol Gaddy. Well, no, that is still an ongoing case. When when Judge Stewart, we think, realized that he was operating, that case was in his court in a complete jurisdictional vacuum. That is the only thing that removes immunity from a judge from being sued by a private citizen. If they operate a case that does not have, it's operating in a jurisdictional vacuum. Okay, they have no boundary jurisdiction. They have no subject matter jurisdiction because the city chose to skip over all the lower remedies of due process in our case. Right. And I thought the part of your summary of your final argument was very, very coherent. You were saying that there was not, the city sued in Chancery Court Yes.
And the city charter specifically requires any dispute of an ordinance has to be, if it's going to go to court, it goes first to city court, which
Correct.
is the judicial branch of the city government.
Mm-hmm.
But Mayor Dwayne Land, who stood on the side of your property one day and said, well, you know, this property is a danger to the public and is a ramshackle place, which of course is not. And so you have to either move or let us inspect it, or we're going to tear it down.
No, his exact
that was
words.
not done under proper process. That was not done under due process. You did not have your rights for a proper procedure accepted and respected, Mrs. Gaddy.
Exactly. And when a mayor of any municipality feels that he has become like some third world dictator in America, that's when we pull out our state constitution, our U.S. Constitution, and teach that man a few lessons. And he drives up in a police car, walks down on our property behind our home where we were out in the yard. And he said, you're going to tear this house down. And I said, why? He said, I deem it unlivable. And of course, my response was, well, I deem about 300 of these terrible, trashy trailers you rent in this valley unlivable. And you need to go tear those down. And of course, the battle was on. He said, well, you're going to do what I say, woman, or I'm going to hurt you. And that was his exact words. And that was in front of witnesses. And a matter of 2 weeks after that.
And the theory, again, is exhaustion of administrative remedies. And that's the question I'm asking my listener. How is it that here in Chattanooga, we have police activity that does not exhaust administrative remedies? If someone has a driver's license out of order, that's an administrative charge and under the Uniform Administrative Procedures Act. And it seems to me should not be handled in a criminal fashion until it's handled administratively. So there's a whole UAPA gap, I think, in enforcement in many cities in Tennessee. But let's not talk about that. Let's talk about your argument about no due process. The case was wrongly in chancery.
Exactly.
And Judge Stewart didn't want to have it because he thought he would be personally liable if he continued to manage that case. Well, but let's get back to the new case, right? We've talked about the old case. Let's move on to what we have.
David, may I just, I wanted to tell
your hands
folks,
are smoking, Carol.
Okay. I wanted to
holding
tell
the blue
the
book.
folks that go to the library. If you don't have a personal blue book, Constitution of the State of Tennessee, Article 1, Declaration of Rights. This is telling us, we the people of Tennessee, what our rights are, but it also tells us what our responsibilities are. And most people are just not aware of this. It says that all power is inherent in the people, and all free governments are founded on their authority, the people's authority, and instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable and indefeasible right to alter, reform, or abolish the government in such manner as they may think proper. Then, number 2, I've quoted this many times in court, and the judges don't like it. The government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. Now, folks, that means that what my husband and I are doing and the stand we have taken for our private property, when you see your local municipal government is out of control, this gives us the responsibility. It tells us we have responsibility to be good citizens of the state of Tennessee to help get that government back in line. And that's the reason it was so important to me. I know David wanted me to give more of an update on this Department of State case. And
we do want to know, what did Mr. Condra say? What was the line of questioning, and what was his response? Because I'm looking at my notes and listening to the recording I made, and the more I think about what you're trying to get at in questioning him, it's not clear. For example, you make a distinction between a description and a legal description.
Yes.
Why did you have him read from the charter?
Well, David,
these different long passages describing the boundary.
I consider a man that has worked as a licensed surveyor up and down that valley, an expert. I mean, he knows the difference in a meets and bounds survey, which contains a legal description. You go out and you want to buy an acre of somebody.
So you can have a survey with another kind of description, Carol Gaddy, that's not legal?
Well, you can have a general boundary description that some people also refer to as a legal description. But I can assure you that if I've got 5 acres and David wants to buy an acre of it to build a house on, he will never get a loan from a bank or a mortgage company unless there is a survey that says meets and bounds, 200 feet east, 300 feet in the other direction. In other words, if you don't have, that's what I, after 25 years in a real estate career, consider a legal description. Now, just about anybody can take a geographical lying area like that valley, where they can say, meander up the Sequatchie River, 5 miles and over the ridge. And that is a general boundary. Okay. That's what was on their ordinance. Now, what has really got the city attorney upset now is the fact that we have asked for the readings of the minutes of the city commission for those 3 months back leading up to 1972, when they say they annexed. And those minutes have not been furnished. I mean, every city has to keep that, the books. They have a city recorder that's the keeper of those books, and we're asking for those, and they still have not.
Are there any vote totals on the 3 readings that occurred?
No, I brought that up. I brought that up. I said, if there is no vote total on the signature page of that ordinance, how do we know? How do we, the people, know
the early readings,
that it even ever went before the city commissioners, which is your local legislative? I mean, I don't understand how a city can function. And of course, the state gives them their charter to be a municipal corporation, but how they can function so loosely and so carelessly, and yet still hold on to their charter.
It's 800-8949, 800-8949. If you have any kind of comment or a question for Carol Gaddy, former real estate maven in Sequatchie County. Well, the big question, I guess, is, Carol Gaddy, is the city of Dunlap, will it be shown to have committed a fraud on the people in the county if it is shown that the annexation was not legal? Is that a fraud? How can a municipal corporation be accused of a fraud? Will it have to pay back all the taxes with interest, you say, or is there some other damages that you can collect? What does it mean to say that there's a fraud possibly in view here by the municipal corporation of Dunlap?
Well, thanks to our wonderful state General Assembly, we've got a new law that was enacted. It was signed by the governor in May of 2017, that any property owner who does their research and it appears that they've been annexed illegally. In other words, what Dunlap has done is an arbitrary annexation, but not a legal annexation. And this new law that's for the people states that city will have to pay back all their city taxes that they have been paid plus interest. Now, a lot of people, I've got David a copy, and I'm hoping he'll publish that for you guys. You just get on his site and print your own copy off, because I've got it here with me, the actual reading. And I'll tell you, in this hearing, I told the judge in my final argument, and David wanted me to touch more on the final argument, and I've got notes here and I haven't done it. But I said, we have legal standing and legal basis to reverse this annexation for all the people, hundreds of property owners.
What happened in Knoxville in recent 4 years, Carol?
Well, as I put in my ending argument, judges in Knoxville annexation, they voided 182 Knoxville annexations. Now, there were 3, I didn't name these judges, but before the Department of State, I just mentioned that these cases, some of them these people had been having their standing for their property rights as long as 15 years. And these 3 judges reversed 182. Okay, that's here in Tennessee, and that is a very good start. This never would have come up. This challenge would never have happened if the city had not come down arbitrarily and decided they wanted to destroy our home and steal our property through eminent domain.
So what you're warning against, Carol Gaddy, is that when officials decide to attack a citizen, they better watch their own papers and effects, because as they go after your effects and property without a warrant or without cause, making several legal mistakes, as I determined, you now are going after you're inspecting their property and their books, and you're finding that they're not in order.
Exactly. And this should be a warning. This is the way it's supposed to operate. The government is to serve the people. The people are not owned by the government. And having a wonderful constitution, state and national, that gives us a good basis. That is our umbrella to stand under. We do, however, have to be bold, depending on the integrity of the men you're dealing with in these offices, and whether they're willing to violate you by throwing you into their county jail in solitary confinement for 3 weeks, as they did me. You have to just stand through it and work your way through it.
Carol, thanks so much for joining us. This is David Toulis. We're talking with Carol Gaddy of Dunlap, an amazing story of courage and a reversal of fortune in her favor and against Dunlap, it seems. David Toulis.
3, 2, 1.
Chattanooga Radio. Digital FM 95.3 HD4. 92.7 FM's news now.
The GBI is trying to track down a missing person. Julianne Mosier from Danielsville, Georgia, went missing about a week ago. She left for Elberton but never arrived. She's reportedly driving a black 1994 Chevy Lumina with the plate number RHR 5983. If you see the vehicle or know anything about her whereabouts, call police. Hamilton County narcotics officers say they seized over 30 marijuana plants from a local man's home. It happened on Retro Hughes Road, where Derry Flippo was arrested and charged with possession with intent to resell, convicted felon in possession of a firearm, among other charges. The investigation ongoing. The GBI confirmed